Right, good evening, everyone. Thank you very much for coming to this event this evening, entitled Can't Buy Me Love, the New Minimum Income Requirement. This event is being live streamed and recorded, and the recording will be available on the YouTube channel, and everyone that's attended in person and online will get a copy of these slides. I now am going to read the fire safety announcement for those of you that are in the room. And basically, that's if the fire bell rings, you just need to follow this lady at the front and she will lead you out of the building to safety. There's also some toilets that are well identified, so just feel free to get up and go if you need to. So after the discussion ends, we're going to be having some very delicious food and drinks in the hub. So please do join us. People usually run away, but it will give us the opportunity maybe to get to know each other a bit more, or just have a nice dinner, to be honest. So what are we going to be covering? So the minimum income requirement for partners has always posed problems for people of limited means, but far more will be affected by the upcoming dramatic raise requiring an income of £29,000, and that is going to come into effect of this spring. So this seminar essentially is so that prudent advisors such as yourselves and clients need to start doing their planning now, because it's going to be quite tricky for quite a few people. So today we have two speakers, Symes and Georgie Rea, and they will discuss with you and speak about the court's reaction to target income so far, how to meet the income requirement and the relaxations under the rules, as well as proportionality arguments when the minimum income just can't be met. So our first speaker this evening will be Georgie Rea. She is and a little bit about her is she's developing a broad public law practice. She has successfully represented clients in statutory appeals before the Immigration and Asylum Tribunals, and in many complex cases. She's experienced in a wide range of immigration matters, human rights appeals, public law challenges, has worked in a private client firm, and she was shortlisted as a finalist for Young Pro Bono Barrister of the Year. So, Georgie, if you want to start, please do.
Thank you very much. Thanks, Ubah, and thank you everyone so much for coming to hear about the new minimum income requirements. So I'm going to be taking you through immigration law's development on maintenance and accommodation of incoming partners, and what the present position is under the immigration rules, considering Appendix FM and dispensation from the rules under that. Mark will then be taking a closer look at the government's policy intentions in 2012, when the threshold was first introduced. And we'll also be having a look at what we can learn from the seminal case of and Lebanon, and cases coming out of Strasbourg on this topic. To finish, we'll both discuss, as Ubah said, the proportionality arguments going forward that can be used for some of our clients who might be caught out by the new minimum income threshold. So since July 2012, the UK's immigration rules have required non-EEA nationals to satisfy a financial minimum income requirement in order to secure a visa to join British settled spouse or partner in the UK. But prior to that, there was still a requirement for the sponsor to adequately either accommodate and maintain the spouse or partner, so that they wouldn't need recourse to public funds. So that rule we can see examples of in 2006 and 2012. But with Appendix FM, which was introduced on the 9th of July 2012, we saw the codification of Article 8, rights of private and family life. Although it did introduce the minimum income requirement, it did include exception 1, which is the exception to the rules-based regime. We then have section 117B of the Nationality and Immigration Act, and that was amended later on, which I'll come on to in a sec. Sorry, I'm clicking between both screens and have realised it's not moving on one and it is moving on the other. And I'll be talking about the unjustifiably harsh exception to the immigration rules as well. So Appendix FM was introduced as a result of the December 2011 Migration Advisory Committee report, that was purported to analyse the impact of non-EEA migration on the UK. And their report on the impact of migration on access to housing and the housing market specifically made a cost-benefit analysis of the proposed minimum income requirement. And this led to the spring 2012 immigration rules, which came into force in July 2012, and that introduced the minimum income threshold of £18,600. But so far, so that's the policy background to Appendix FM and that minimum income requirement. But so far, we don't seem to have an indication of the new policy background for the change in these rules. So the chair of the Migration Advisory Committee, Professor Bell, has written to the Secretary of State for the Home Department saying that a rapid review of the new immigration salary list by the 24th of February 2024 will be such a challenge that they'll have to exclude usual stakeholders from consultation. So it's unclear exactly the background to this policy and the research that it has been based on. I'm now going to take us through Appendix FM, which I'm sure all of you will be familiar with, but it will set the scene for the new rules. So the financial target minimum income is £18,600 with an additional £3,800 for the first child and £2,400 thereafter for each extra child. So to put this in context, Tier 2 visas required £20,000 in 2011. Savings or alternatively or additionally should be at £16,000 in addition to 2.5 times the difference of the difference between the available income and the minimum income requirement threshold. This also applies to post-flight partners of international protection holders. Previous, current or prospective employment earnings of migrant partners are not taken into account for entry at the entry clearance stage. But those who are in receipt of specified disability-related benefits and care allowances will continue under the old test. So that's just the test for maintenance and accommodation. And you can see the list of those specific disability allowances at EECP 3.3. Here I've just set out more clearly the categories of specified income which need to be accumulated and will be counted towards the 18,600. But you can see it's an incredibly restricted list and it will only be for joining partners, it will only be the income from the sponsor that is counted. Now, to go beyond these categories to make up the minimum income, you're only allowed to do that if you meet the rule in Appendix FM Gen 3.1 and 3.2, which we'll have a look at. And there's a further in Appendix FM SE. So there's the exception to the Appendix FM regime generally is found in EX1. We know both of those tests, the genuine and subsisting parental relationship with a British citizen or child, and it would not be reasonable to expect the child to leave the UK, or a genuine and subsisting relationship with a partner where there are insurmountable obstacles to life abroad. So obviously those are difficult tests to meet. In 2014, the Immigration Act inserted Section 117 into the Nationality, Immigration and Asylum Act, and that set out the public interest requirements which apply to courts and tribunals when deciding Article 8 claims in immigration cases. That includes here that it is in the interest of the economic well-being of the United Kingdom that persons who seek to enter or remain in the United Kingdom are financially independent. And that clearly places financial independence on the government's agendas and sets the background to the changes in 2012. We've got here a Supreme Court case of Rupiah, and the Supreme Court decided that the definition of being financially independent meant financial independence from the state. So that was a better interpretation of this provision. And they rejected Lord Justice Dale's interpretation in the Court of Appeal, where he said that you had to be financially independent from other people. So of course you can and will be financially dependent upon your sponsor, which is why there's the income requirement in the first place. So Mark is going to come on to analyse Lebanon in more detail. But if the exception in EX1 cannot be met, then the application should be considered under Gen 3.2 of Appendix FM. And that was introduced on the 10th of August 2017 to fill the gaps that the Supreme Court identified in Lebanon, so where Article 8 wasn't sufficiently protected. And this will apply in circumstances where the financial requirements aren't met. There are exceptional circumstances such that refusing the application would have unjustifiably harsh consequences for the applicant or their family, taking into account as primary consideration the best interests of any relevant child. That doesn't exclude you from meeting the rules entirely, so it's not as generous as EX1. It just means that there are other sources of income that can be considered towards meeting that threshold. And they have to be credible other source of income, but I'm sure that a lot of your clients would even struggle to meet the threshold at all, wouldn't have any other alternative sources that could give them a guarantee, for example. But it does make it a little bit easier altogether. Right, now I'm going to pass on to Mark to take you through the government's policy intentions.
Thank you, Georgie. So just as Mark is setting up, I feel like he's a barrister that needs no introduction. He provides advice and representation in all areas of immigration, asylum and human rights, including European Union free movement law. He's represented clients in every court from the Tribunal to the Supreme Court and the European Court of Human Rights. He regularly represents clients such as yours who face separation from their loved ones. And he is one of a small group of top-ranked barristers that are band 1 in Chambers and Partners and legal function. Thank you, Mark.
Thank you very much. Nice introduction. So I had this vision of making this talk really entertaining by packing it full of romantic references from Romeo and Juliet and so forth, but I injured my shoulder so badly yesterday. I actually spent the morning in tears with my osteopath. So that may not really happen, but we'll see if we manage to get 1 or 2 in along the way. Anyway, government policy intention. So there's some interesting background on this to read in the MAC report. So the very famous Migration Advisory Committee report in 2011. And the MAC, the MAC, we often hear the commercial immigration fraternity speaking of the MAC because they pay great attention to them in order to try and work out what the future of managed migration is going to be. In human rights law, we very seldom have regard to the of the MAC, but the most famous report they ever wrote, nevertheless, was the Family Migration Route one, which came out, I think, at the end of 2011, and was a very detailed consideration of how it was that the government might want to enforce a minimum income requirement. And that's one point. You know, this is when the minimum income requirement came in summer 2012. It was heralded by a whole series of policy discussions. You know, there was the November 2011 paper, there was the statement of changes and various briefings in Easter 2012, and then there was the rules themselves that actually took effect in famously, what is it, 11th or 12th of July 2012. Now, you know, we're not really seeing so much of a considered build-up this time. The 3 choices identified by the MAC report about how things might have been benchmarked on a rational basis was to pay levels, which would require taking the average, mean average, median average, average, whatever, of national earnings and benchmarking applications to that. And then another possibility was taking the benefits threshold for a 2-adult household, which they said was 18,600. I think that's the threshold at which you wouldn't normally be receiving any benefits. And they reckon that taking the benefits threshold as the target, which of course is what was done, would reduce the annual issue of partner visas from 40,000 to around 25,000. And then the other possibility was net fiscal burden, which was basically assessing the likely contribution of the migrant to tax over their lifetime, subtracting the likely consumption of benefits. And the MAC looked at that and they waffle on about it at length, but they make the point that you have to make so many assumptions to come up with a credible thesis on that, that is almost meaningless. And the fact is that the vast majority of people are significant contributors to fiscal circumstances during their lifetime, during their working life, and significant sponges on it during their retirement, unless they're very wealthy. And so ultimately it was all a bit meaningless. And no doubt, that is ultimately why it was that the choice was taken. Other points that were made were that housing costs were notoriously unverifiable and capable of application. And that the national minimum wage wasn't a suitable target. At the time, it would have been 13,400, yeah. So in choosing 18,600, they were choosing a target that was much higher than what the national minimum wage was. But it was remarked that was a level itself requiring taxpayer subsidy. As Georgie pointed out, before hallowed days, before July 2012, the target was far lower. The target was just working out, going to the LASA website, yeah, and looking at their nice chart, and then puzzling around it and thinking, oh, okay, well, how many benefits does this family group qualify for, and how much will it go up by the migrant's arrival? And we worked that out. And basically, on average, that target was £5,500 a year, a very low target compared to the 18,600 that was ultimately selected. Ilpa made the smart advocate's point that why was it necessary to raise the income threshold from the benefits level? Because to do so would suggest that the UK level of benefits wasn't adequate. But the government has ignored that. Average earnings at that time was 26,500 nationally. For men, 28,700, for women, 20,100. So immediately, we see the foundations of a possible discrimination argument in the future, because obviously average earnings for women are significantly less. Another issue was the big difference between London and the South East and the rest of the country. Most people in London who were looked at by MAC were earning significantly more than the national median, whereas most people in Wales and Northern Ireland and the North East were earning significantly less. And then they became concerned, saying, well, what about would people be moving around the country in order to exploit an advantage if the policy, if the immigration rules went by postcode? Someone made the point, the Supreme Court, I think, in Lebanon made the point that of the 422 occupations listed in the National Statistical Office's list of jobs that people get up to, 301 had earnings below 18,600. So it's like 3/4 of all job holders were knocked out, even by that relatively modest figure. And they reckoned that MAC reckoned that nearly half of the applicants in 2011 would not be able to meet the 18,600 threshold. So the Home Secretary has been announcing changes, and no doubt we've all been following this with some fascination. So we see the 5-point plan to reduce immigration announced in December 2023, and the 5 points are no dependence for care workers, massively increasing the sponsorable salary. The moment the sponsorable salary is, or whatever it is, 22,400 or something, isn't it? With various increments depending on, or 26,200. You see how much skilled worker work I do. Whatever it is, it goes up and down depending whether or not you're in category A to category F of the skilled worker rules. But anyway, that's going to go up massively. The shortage occupation list is going to become the immigration skills list. The graduate visa apparently is thought to be subject to abuse and is going to be looked at with scrutiny. And the 5th one is this, what we're talking about this evening, the minimum income requirement. On 21st of December, the Home Office issued a revised plan in relation to the salary threshold, where they began to make noises about how they wouldn't actually be going up quite as was originally announced. It wouldn't be an immediate hike to 38 grand or whatever. It would be going up in stages. And then also they announced that it would not apply to extensions, whereas originally it had been intimated that it would apply to people who are already here, which would have been amazingly mean, wouldn't it? Like if you're here and living your life here on a settlement route, and then the rules are changed, or you can no longer meet the settlement criteria, that would be a problem. And of course, the government had to change that because they lost the the highly skilled migrants case, one of the most famous of immigration cases in the late 90s, the only case ever where anyone ever wins on legitimate expectation grounds, because the highly skilled migrants argued successfully that they'd all been told that they could settle in the UK. So obviously the government would have been absolutely stuffed had they taken people on a family settlement route who'd already come here and tried to change the rules for them. So good sense prevailed. But amongst, amongst this rationale, amongst their set of materials, that we've so far seen, announcements and counter-announcements, and then, as you see there, proposals that it will go up in stages to 29,000 and 34,500 and then 38,700 by around a year from now. We see no real policy discussion. I have a phrase, Juliet, rationale, O rationale, wherefore art thou rationale? No sign of a rationale anywhere in any of this material. And I don't know if it's coming, as Georgie remarked. The MAC committee, when asked recently to analyse the skilled worker salary thresholds, turned around and said, well, we will, but on the timescale you're giving us, we haven't even got time for a consultation. With an unpromising way of doing a survey into salary levels, one would think. So, goodness, what hope have we got if the MIR is coming in spring 2024? What hope is there of a significant policy analysis before then? Is Parliament going to debate it? Well, I don't know if Parliament's going to have a chance to debate it. You may recall that there was a farcical non-debate in summer 2012, which the government then referred to in order to try and say that the immigration rules in Appendix FM had the imprimatur of Parliament. And in fact, there was a 2-hour discussion, which the entire opposition rightly refused to participate in, simply by asking only one question, really, which was, what is this proposed discussion supposed to be about? That was the level of democratic engagement with the FM regime. But look at this time, we're going to get rather less. Right. On to Lebanon and ECHR cases. So in the case of Lebanon, landmark piece of litigation, obviously, and it didn't really, it kind of damp fizzed a bit in the end. The ratio of Lebanon is, well, Lebanon is, well, none of this really matters very much because on appeal, people can win if their case is strong because of the principle of proportionality. The litigants in Lebanon, though, were challenging the MIR in principle largely, which is an interesting, it was an interesting effort. I think maybe there were 4 of them or 5 of them. Only SS Congo had been through the appeal system, and SS Congo came out the case very well. SS Congo, despite winning in the tribunal on a duff point, won in the Supreme Court simply because they felt they were nice to that litigant. Come back to SS Congo in due course. The others all basically argued that there was no point in making an application under Appendix FM because it was doomed to fail and they were going to go through an appeal system or not be able to afford to go through an appeal system and just generally have a totally unhappy time of it. And that would be interesting, we had Georgie and I had a Zoom with JCWI this afternoon, who had always a kind of ahead of the game in terms of thought leadership in this field. And they were making the point that it would be, when should one bring a challenge? What kind of client should bring a challenge? Is the very client who brings a challenge in so doing admitting they don't have a viable case in the first place under the rules, and will that disadvantage them in their general life, whatever value their crusade brings to immigration law more generally? So people are going to have to think about that with some care. Anyway, things that we come out with from Lebanon, most famously, I suppose, is that Article 8 cannot be fitted into a rigid template provided by the rules, so as in effect to exclude consideration by the tribunal of special cases outside the rules. This would be a negation of the evaluative exercise required in assessing proportionality. And that, of course, is why the immigration rules had to be changed and why they had to produce, why they had to inject Gen 3.2 into the Gen criteria of Appendix FM and bring in the proviso that in exceptional cases, i.e. where the outcome would otherwise be unjustifiably harsh, applications could still succeed. Unjustifiably harsh proportionality. Juliet again, a rose by any other name smells just as sweet. The Home Office couldn't quite bring themselves to call it proportionality, but obviously it is the same thing. Not everything in the rules, says the Supreme Court, are matters of high principle. They say that there's a big difference between proving you have the income by different kinds of evidence and the absolute level of income. That's the worst thing about Lebanon. Lebanon, 7-judge panel, the 3 greatest superheroes, Wilson, Kerr, and Lady Hale, all 3 of them there, you couldn't want for more. And they uphold the principle that actually it's very hard to see anyone ever winning their case if they don't have 18,600 or whatever the other target is. That's them. What's the Lord Reed court going to make of the same arguments 10 years on? But nevertheless, what is massively important, this is why Georgie's contribution was so useful in summarising the various ways under Appendix FM you can rely on third-party support and so forth, is that how you get to that target is very, very flexible. It has to be flexible. An Appendix FM, I shouldn't even mention Appendix FM when I said that, the point of Lebanon is that no rules can capture the infinite variety of ways in which people might demonstrate that they can meet the financial target. And those rules, oh my goodness me, I did one once on public access and never doing one of those again, third-party support, cogency, verifiability, every single uncle. Had the uncle ever promised anyone else any other money in their life? Has the uncle got a job for, is the uncle on a 20-year contract earning £62,000 a year? Ridiculous. The stuff they want is just ridiculous. And obviously it is, again though, those rules are simply a reference point, the starting point, the end point of the proportionality exercise. Lebanon also said, and this was knocking back the government's arguments about how the House of Lords in Huang had confused things. Lebanon said that actually it was perfectly proper for judges in immigration appeals to take account of the public interest in a consistent, fair, workable, predictable system. Think of the damage to good administration and effective control if a system is perceived by applicants internationally to be unduly porous, unpredictable, or perfunctory. Well, I don't know if applicants think the UK immigration system is unduly porous at the moment. I think they probably say it's pretty unpredictable and perfunctory. I imagine those 13,000 asylum seekers who found their claims abandoned just turning up an hour late for their interview, I suspect they would sign up to perfunctory. And the guidance, of course, famously, the Lebanon finds that the guidance requiring children's best interests, to be given a primary consideration, but only in exceptional circumstances, were found unlawful. And that is why Gen 3.3 is it, says that a child's best interests are always part of the balancing exercise. So the Supreme Court, good positives and negatives from the Supreme Court, not a read or rights advocate maybe, but the ECHR, they observe that the ECHR always emphasises the fact that states are entitled to control their borders. The final thing to take from Lebanon, the fate of SS Congo. Yeah, it's quite important when we're all doing millions of money appeals in the tribunal in 2 years' time, arguing against Home Office refusals because people don't earn 38 grand. SS Congo won his case in the tribunal. Can't remember too much about SS Congo yet, but the sponsor was a refugee. It's an amazingly strong case. Sponsor was a refugee. The reason it wasn't refugee family reunion was it must be a post-flight relationship. He'd been here. He'd been British citizen naturalised since 2005. And this was, that was several years on. Would have met the old rules before the rules changed. The relationship long predated the rules change. It was a very strong case. But anyway, the tribunal had allowed SS Congo's appeal mainly because he earned much more than the minimum wage, which was then 13,400, and he earned 17,000. And the Supreme Court say, no, the tribunal were wrong to look at that. 18,600 is a very powerful benchmark. But they say that, oh, well, look, the fact is he did the right thing. He pursued an appeal. He tried really hard. He fooled the judges. And we're going to let him keep his victory because we're not reopening that 5 years later. Amazingly jamming success for Mr. SS Congo. Strasbourg, I mean, Strasbourg is much more conservative than the English judiciary on this matter, I would suggest, yeah. I mean, Jeunesse and all these cases basically say you have to show insurmountable obstacles to life abroad, with an Article 8 case if you don't meet the national rules, or exceptional circumstances. So that's almost exactly the same as the Appendix FM regime. So it's not like they begin to find a lot of succour from Strasbourg. Konstantinov against Netherlands upholds the minimum income requirement that they had in Holland at the time. And indeed, it was quite clear. I mean, there were several very important decisions in Strasbourg last year on refugee family union, which briefly looked like it might become important to us and then kind of faded away a bit because the government decided to end the differentiation regime. But those decisions in Strasbourg, whilst they were very good, if you were a French lawyer or a Dutch lawyer or a German lawyer, would start from a very conservative premise if you're a UK human rights lawyer, because they said that refugees could be expected to meet the minimum income requirement. They don't even have a refugee family reunion rule that waives the financial requirement in many European countries, and Strasbourg seemed to be happy with that. So Jeunesse is the last key case from the Grand Chamber on proportionality, and it points to important factors as settled status or strong ties with the host country, family life already having been created when settlement was achieved, both applicant and sponsor being already resident in the UK, the involvement of children, insurmountable obstacles. Interestingly, they one thing in Jeunesse they say is that decision-making processes must be sufficiently flexible, speedy, and efficient to respect family life. You do wonder, don't you? I mean, even the claim, for what weight you give it, is like they take 11 months to deal with anything vaguely difficult, don't they? Arguments on proportionality going forward. So there's quite a good article by this chap, Chris Rea. I would actually get it was so good I was going to steal the point, and I got embarrassed because my epistemology for this talk is so narrow that it would be obvious. So Chris Rea writes this nice little article, which is on the UK constitutional law blog, but I think you can also find it on EIN, in which he muses on some points falling from Lebanon and the proposed raising of the minimum income requirement. And he says that should rules be... So his first point is that it seems that in Lebanon, they would have applied a test in checking the lawfulness of the immigration rules as to whether or not they would be unlawful in all or nearly all cases. And he says that's a wrong test. Now, I'm not sure that he then quite cites the right test, because the right test is surely, because we've had it shoved down our throat recently in Rwanda and other cases, trafficking cases, in A and B Eritrea. The right test is whether or not a policy encourages unlawfulness. Also quite a mean test, but anyway, there we are. But the point is that attacking the rules is going to be attacking quite a high standard. Is to be measured by quite a high standard. Then he makes a point. He says that given that the big takeaway from Lebanon was that it didn't really matter whether or not you could meet the letter of the rules, because Article 8 would always have to fill any gaps. He said, well, where did that leave the legal imperative of certainty, which is what the Home Office had waffled on about in the first place, and which the MAC report had gone on as being a central policy objective? Because if the Home Office could make £100,000 the MIR, it would seem that the Supreme Court would presumably have come back and said, yeah, fair enough, because Article 8 will just fill any gaps. Also quite a good point. He reminds us that the case law now requires cogent and verifiable third-party support. And of course, Appendix FM recognises this in its niggardly way as something that you can rely on. And he says that, ironic then, isn't it, that actually basically anyone with a rich relative who can gift them 60 grand, 62.5 grand or whatever, will be able to qualify, because you only got to have that money for 6 months and it will be treated as your money. Whereas if you're like a striver, a northeast coal miner, if there are any such people still not extinct, earning £29,000 in a year's time, you won't qualify, even though you might be, the grafter might be the person who most of the country would think would be the one who ought to get in, ought to get their partner in under the rules. universal credit, he then makes some points that were above my pay grade on universal credit, yeah. But anyway, in short, yeah, universal credit is quite complicated. But the short point he makes is that actually under universal credit, the arrival of a person who's not settled, which would be anyone obviously under Appendix FM, presumably, adds to their household income when income is calculated, but cannot add to their household entitlement to public funds. So actually, it's not like if the policy imperative identified by MAC in 2011 is in fact already completely dealt with by universal credit. So why go with that kind of thinking at all, as opposed to reopening it and having a new debate? And the final point is that I thought of this one, might I claim that one of these five I'd actually stumbled upon myself, was that Section 117B. Section 117B, of course, post-dated Lebanon, but my God, massively important on appeal. Judges automatically overturned by the fetishists at Field House for forgetting to mention Section 117B. It's the biggest appeal point 3 or 4 years ago. Biggest appeal point. Loads of judges in the FTT, soft, tough judges at Taylor House, allowing appeals left, right, and centre, and forgetting to mention Section 117B. Constantly being overturned. So it's an important milestone. But the Supreme Court in Rea tell us that the key policy imperative is not being dependent on the state, and that third-party support is perfectly permissible. Which again, his thesis is that rather undermines the original rationale for the MIR being chosen at its level. I noticed one debating point online on the House of Commons had a briefing recently for muddled MPs about the possible changes. With obviously a lot of people are saying, will the savings threshold change? And of course, well, we don't know because they haven't told us very much about anything, have they? But obviously it will change under the rules as they are now, because the savings threshold is not an absolute. It's a calculation, isn't it? The savings thing is 16 grand plus 2.5 times the figure by which you missed the target. So obviously, if the target goes up, the savings threshold is going to go up without any extra law being created about the savings threshold independently. So the final point, just some thought going forward, yeah. So when we're stumbling around thinking about how we're going to argue our clients' cases from this spring, one inspiration is the MAC report. And having delved in it at some length, I mean, about the most powerful point I could find in it was that they said there was a strong case in principle for including the future earnings of the sponsored migrant because it's total household income which determines whether there'll be a burden on the state. Now, of course, in an entry clearance case, the migrant incomes are not included under the immigration rules, are they? But there's MAC, MAC are the institutionally competent, it might be said, body who are very good at thinking about this kind of issue. So that's a powerful thing to shove in the nose of first-tier tribunal judges. MAC made the point that their report was only on economic considerations. It didn't touch on the wider legal, social or moral issues. So that is an encouragement to look at social or moral issues in proportionality. Housing costs, obviously, housing costs I touched on in the same way as income, really, when I talked about the obvious differentiation nationally. What about discrimination? Given that far more people were entering this route, far more people who were entering the route were women than were men. And so does that not hold up the possibility of a discrimination argument? And discrimination law, I mean, a lot of discrimination law talks, none of which I have yet properly understood. But as I understand it, there were at least 3 kinds of discrimination: direct discrimination, indirect discrimination, and something mysteriously called preliminary discrimination. But the big point, really, to never mind what the letter of all those legal tests might end up being, was that the government have not put up any tangible justification so far for these changes. And if anyone can come up with a discrimination case, these laws are facially neutral, but obviously have a differential impact on some communities or groups, statuses, then they're obviously going to be struggling on justification. They have to come up with an objective and reasonable justification for what is indirectly discriminatory, or what is Article 8 ECHR read with Article 14 ECHR discriminatory, and they haven't so far. Georgie, do you have anything to add on proportionality things?
No, but I think we might open up some questions.
As Juliet would put it, Parting your stuff speaks of it, but we don't have to because now we can have questions. There are drinks, of course.
There are. Thank you so much to all of you that have come and attended in person on this cold Tuesday afternoon or evening. Just a reminder that these slides will be available after the seminar, and this will also be available on YouTube. Thanks to those who have attended online, but those of you who are lucky to be here in person, dinner available now. So thank you very much, and thank you to our speakers.